was addressing issue 1A.
Yes.
And I just about completed the first way in which we put our case, which is a matter of general principle.
Yes.
There's one other reference I should have given the court. There is, in the bundle of authorities, it's volume 3, tab 64.
Tab?
64.
64, yeah.
And it's the commentary by Professor Miller. He's writing as a matter of Scottish law.
Yeah.
But he comments on the relevant point as a matter of principle as a matter of English law. And he says that the position in England, this is a mirror in a sense of what Mr. Justice Park said in Major and Brodie. He says that the effect in English law is that the partners of the top partnership become members of the bottom partnership.
Yes.
I quite accept that that is a treatise on the law of Scotland, and he's expressing a view about the law of England. I thought you ought just to see that. So the second way in which we put our case on issue 1A, and this is to address the way that the Upper Tribunal decided it. The Upper Tribunal said, in effect, well, your general proposition isn't automatically right. What you've got to do is look at the agreements that the parties have entered into to see whether you can spell out of those agreements a conclusion that the partners here in UK LP admitted as partners the partners in Cayman. The Upper Tribunal said, well, looking at the substance and reality of the relationship in light of the various documents, that wasn't made out. Now, if one starts with the Partnership Act 1890, trite law that in order to have a partnership you need persons carrying on a business in common with a view to profit. That's section 1. Section 2, subsection 3 of the Partnership Act 1890 looks to receipts by a person of a share of profits as prima facie evidence that he or she is a partner. This is in volume 1 of the authorities, tab 1. Statutory term is person, not further defined. There is nothing in the Limited Partnership Act 1907, for our part, that bears on this question. It just doesn't address it at all.
Am I right in thinking you have to be a natural person to be a partner of an 1890 partnership? Do you have corporate partners?
Yes.
You can have corporate.
Yes. It's not uncommon for there to be a corporate partner that might be made the managing partner of an English general law partnership.
We're talking here about who is a partner in the UK
LP.
and therefore that is governed by English law.
Yes. And it's a partnership under the Limited Partnership Act 1907, and if I put it simplistically, that adapts the 1890 Act, but where it doesn't, the 1890 Act and the Common Law of Partnership applies. So the 1907 Act doesn't tell us anything relevant to this question. What the Upper Tribunal said, and the authorities establish, is you do need to look at the substance and the reality of the relationship. We have no difficulty with that. And you've got to look at the deeds that were in fact entered into. So here, RBS is a member of Cayman LP, and Phyled later becomes a member of Cayman LP. Cayman Limited is always the general partner in Cayman LP, and we know under the Cayman LP deed that first RBS and later Phyled have an entitlement to profits under the allocation waterfall in clause 12. We also know that the partner admitted to UK LP is, quotes, Cayman. And that entity is admitted as the special limited partner.
And at this stage, you are submitting, I take it, that Cayman LP means the partners in Cayman LP from time to time.
Yes.
No doubt you will deal with the position if you're wrong about that, and it only means the partners in Cayman at the time of the contract in question.
Yes, I'm going to come to that. As your Lordship has just identified, these submissions are a different route to my same conclusion. Where I end up is the same, whether it's a matter of general principle or a matter of reading the documents. Under each of the partnership deeds, the GP was given the ability to admit new partners, in effect as it saw fit. It's clause 20.1 of the UK deed, supplementary A, tab 2, page 41, and it's clause 20.1 of the Cayman deed, supplementary A, tab 3, page 84. So the admission of new partners was in each case in the control of the general partner.
Subject to conditions.
I'm reluctant just to accept that from my Lord.
The general partner in UK LP was entitled to admit new partners, but it was a precondition of admission of a new partner.
Execute a deed of adherence.
Exactly.
My Lord, yes. That is right.
So the Upper Tribunal were correct, I think, in saying that in order to admit a new partner, you need the consent of all partners, but the limited partners gave their consent in the deed to the general partner having the power to admit, but only on terms, and the UK LP deed defined further limited partners, again, by reference to somebody who had signed the deed of adherence.
That is correct. Yes.
Which Philed didn't.
Philed signed a deed of adherence to Cayman LP.
Yes, but not to UK.
But not to UK.
Do you accept, I think you have, that the way in which clause 20.1 of the UK deed is written, you have to execute a deed of adherence before the general partner can admit you?
That, I think, my Lord, is right, yes.
So if you don't execute a deed of adherence, the general partner has no authority from the other partners to admit.
Yes. Because the first sentence of 20.1 ends prior to such admission.
Yes.
Yes.
Yes, and it's also described in the last sentence as a precondition. But that's a third party purchase.
That's a third party purchase. But my Lord's point is that's right. Yes. Now, the revenues case below, accepted by the Upper Tribunal, is that the parties intended only that Cayman Limited should be admitted as a partner in UK LP, notwithstanding the reference to Cayman LP as the partner. And we say that fails to give effect to the careful distinction drawn in the deed itself to the difference between Cayman Limited and Cayman LP. If one has the UK LP deed, supplementary bundle A, tab 2, the references to Cayman LP as the special limited partner. And that is the desire to admit the special limited partner is recorded in recital G on page 21.
Yeah.
And then the limited partner definition on page 23 is the corporate limited partner, the special limited partner, and the individual limited partners. But if you then look further down the same page, page 23, there's a term new GP, meaning Cayman Limited, which is the general partner of the special limited partner. That term, new GP, is used on occasion in the draft where what is meant is Cayman Limited. So as an example, if one turns to page 34, this is clause 13.4b. These are the partners' accounts and distributions rules. 13.4b is a rule about distributions. Distributions shall be made at the end of each month to the special limited partner in an amount equal to an amount, if any, sufficient for new GP to pay interest payable under the facility agreement. So that's relevant for two reasons. It's an instance where it was necessary to draw a distinction between Cayman Limited as new GP and Cayman LP as the special limited partner. And it serves to emphasise that this deed is carefully drafted such that when the parties wanted to refer to Cayman LP, they did so. So the bald conclusion of the Upper Tribunal, paragraph 60, that one can tell from this deed that there was an intention only to admit Cayman Limited, is not borne out by the deed itself. And in our appeal skeleton argument, we set out, by way of commentary on the Upper Tribunal's reasoning, our paragraph 74, our answer to each of the elements relied upon by the Upper Tribunal in their conclusion that there was no intention to admit any person other than Cayman Limited. I don't want to detain the court in walking through this when the court perfectly well read this for itself. I do want to make one point. The Upper Tribunal made reference to evidence that Mr. Dodds had given in cross-examination before the First Tier Tribunal. This is paragraph 61.1 in the Upper Tribunal. And the relevant exchange was Mr. Dodds was asked if the intention was for Cayman LP to be the partner in UK LP. He said yes. He was then asked whether RBS had signed the UK LP deed, and he said he did not believe that it had. And it is that evidence that the Upper Tribunal find to be significant when we are not contending that RBS did sign the deed of adherence to become a partner in UK LP, nor did Finland. More significantly, if one is to judge the intention of the parties to the deed of UK LP in determining whether they intended to admit only Cayman Limited, one has to look to the deed itself and the other surrounding documents. The evidence of Mr. Dodds is not relevant, nor is it admissible. Now, there's a case that the commissioners have added to the authorities bundle, a case called Hamid. Not sure we need turn it up, but it's in the second volume of authorities at tab 50. Paragraph 57 of that decision says that such evidence is neither relevant nor admissible. So with respect to the Upper Tribunal, that's not a factor that can bear upon this question. Instead, what it has to do is to read the documentation that the parties entered into, from which it is clear that a distinction was to be drawn between Cayman Limited and Cayman LP. And of course, if one stands back for a moment, this argument is said to justify the taxation of Cayman Limited. Cayman Limited was not made a partner of UK LP. The Commissioner's case is odd. They say that the reference to Cayman LP as the partner in UK LP doesn't justify a conclusion that PHI-led is to be taxable, but it is said to be justification for a conclusion that Cayman Limited is taxable, in a world where neither PHI-led nor Cayman Limited signed a deed of adherence to the UK partnership.
Who did sign the UK LP deed on behalf of Cayman LP?
Cayman GP, Cayman Limited as general partner of the Cayman LP.
Do we have that signature?
It's tab 2. Supplementary A, tab 2. Just for your notes, governed by English law, that's page 52.
I couldn't find it myself, Mr. Peacock.
My lord, no, I can't immediately see it. I have seen it though.
I'm reminded that I don't think this page ever emerged in the First Tier Tribunal. The page of the limited partnership agreement from 2007. Which,
very curious.
we do have a signature in the LLP deed, and that's actually, well, there's a different name on the LLP deed, but not for this deed. It just wasn't before the. We looked for it, but it never turned up.
There we are.
That's where we can delve. I will need, not reminding, I'll need telling what happened below. So perhaps we can look at.
But your understanding is that Cayman Limited signed it, qua general partner of Cayman LP.
Yes, that's my understanding.
Well, the limited partners couldn't have, could they? They couldn't have signed. They weren't allowed to.
No, only the GP could sign. The point I was just making was that it is common ground between us that neither Cayman Limited nor RBS nor PHI-led ever signed a deed of adherence in their own right into UK LP.
But if Cayman Limited signed the deed, why isn't Cayman Limited liable on a contract which it signed? May have done so as agent, but why not? Why shouldn't it be liable?
Conventionally, the law would say that it is. It's liable as general partner of.
Yeah, because it's signed.
Because it's signed. qua general partner.
And I mean, although you rest on this proposition of law, does the fact that it's a limited partnership and the limited partners cannot contract consistently with its terms have anything to do with it? That wasn't the Brodie case, for instance. It might be different in the case of a limited partnership, where the limited partners, all they can do is sit and watch the general partner do stuff.
That is correct. But it is said here to justify, I'm not right on 1B, I'm testing in a 1A world where I may not be right on 1B. It's said to justify a conclusion that Cayman Limited is taxable, notwithstanding that it is signed as GP of the
Yeah, I
Cayman
follow.
LP.
But if a limited partner becomes a partner in UK LP, why are they limited partners in UK LP? They've simply been admitted as partners.
Putting aside the limited partnership status of the UK entity, that would be right, yes.
Yeah.
But the court has this, but the conundrum is Cayman LP is described as the partner. Question, what does that mean? Does it mean you can tax Cayman Limited or file it? We say, well, as a matter of principle or as a matter of the documentation, there was a distinction to be drawn between new GP Cayman Limited and the partnership. And if I'm right about that, that has the result that, in a sense, the right person gets taxed. Because that's filed, it has the entitlement under the Cayman LP. So I won't walk through our answer to the Upper Tribunal's decision that's set out in our skeleton. The Commissioners run some arguments in their skeleton in this appeal, paragraphs 32 through to 49, in order to bolster the Upper Tribunal's conclusion, if not its reasoning, that only Cayman Limited became a partner in UK LP. So firstly, the revenues say, well, the identity of partners to a partnership involves looking to the substance of the relationship. We agree. They say that's a question of fact for the first tier, which the Upper Tribunal and the Court of Appeal can't interfere. But whether that's right or not, as a matter of principle, if one looks at what the first tier decided here, they did not decide this as a matter of fact. They decided it on the reading or the construction of the documents. That's the first tier at paragraphs 103 to 109.
103 to
109.
Q.
Secondly, the revenues say, well, a court can look to extrinsic evidence to identify the parties to an agreement. And yes, they're right about that, but that's not an issue here. The identity of the person is known. It's not a question of who is this person. The relevant question is RBS or Filet the partner, or is it Cayman Limited? And that, we say, is a question of construction of the relevant documents if I'm not right about my general principle. Thirdly, the revenues say, well, you can have such a thing as a sub-partnership, where one partner in a partnership agrees with others to share his or her share of profits with others without making them partners in the bottom partnership. And that's right, as a matter of law, you can have that. The relevant question here is that what the parties agreed? We say no. The revenue then say, this is their paragraph 41, the question is whether Cayman Limited, as GP of Cayman LP, had authority to bind the partners of Cayman LP to become members of the UK LP. And that may be another helpful way of asking the same question. We say the answer to that is yes, because it was empowered as GP of Cayman LP to enter into the UK LPD whereby Cayman LP became the partner in the UKD. And again, one arrives at that conclusion by a proper reading of the deeds as a whole.
Under the Limited Partnerships Act, the general partner has authority to carry on the business of the firm,
Yes.
but he does not have authority to pledge the credit of the limited partner, because they're not liable for the debts and liabilities of the firm, save to the extent of the capital that they've put in. Is that not right?
That is right, my lord, but there is a...
So on what authority do the general partner have to expose them to any contractual liability by signing them up to a contractual relationship?
Pursuant to the Cayman LP deed, the general partner has the authority to conduct the business of the Cayman LP,
Yes.
which is expressed to be investment in the UK LP so as to carry on the investment management business. That's clause 6.1.
So it's a special. This doesn't come from their general status as general partner, but a special authority in the Cayman LP deed, clause 6.1.
Yes. Tab 3, page 75.
So the partnership's business is to become a limited partner in UK LP.
6.2 gives the partnership all the power necessary to carry on the business. The general partner has conduct of the business.
Let's assume that wasn't the partnership's business. Suppose the partnership's business was buying and selling widgets. When the general partner buys 100 tons of widgets, enters into a contract, limited partners are not liable on that contract, are they?
No.
Because the Act says, I mean, if it was an 1890 Act partnership, when one partner has power to bind the firm and binds all the other partners, and they all become liable on the contract. But in a limited partnership, the limited partners, under the Act, are not liable for the debts and obligations of the firm beyond their limited capital liability.
Yes.
So the contract for the purchase of 100 tons of widgets is not a contract to which the limited partners are parties. Or are they, do you say? They're parties, but they have no liability under it.
Well, they are parties pursuant to the execution by the general partner, but they have no liability beyond their limited partner liability.
It seems a very odd sort of contract. If you're the widget seller, who do you sue? You sue
The general partner.
You sue the general partner. You don't sue the limited partner.
You sue the general partner and leave the obligations of the general partner to be worked out with the limited partners as his property.
Well, if that's right, why is it there any difference between a contract for the purchase of 100 tons of widgets and a contract to enter into an LPD? Why is that? I mean, suppose there were obligations. Well, there are obligations, presumably on the Cayman LP under the UK LPD, but owe obligations of honesty and the like to its fellow partners. If the fellow partners discovered some impropriety by Cayman LP and wanted to sue it, they would sue the general partner. Why is it any different? They wouldn't sue the limited partners who aren't responsible for the debts and obligations of the firm. Why would it be any different?
Well, I think that's a product of the tested partnership being a limited partnership that can only act through its GP.
Yes. But I'm having difficulty understanding how the clause 6.1 in the Cayman LP deed, which tells you what the partnership business is and confers on the general partner authority to carry on the business, how that enables the general partner to sign the limited partners up to a contractual relationship in the form of the UK LP deed, which is what you need to establish.
The answer, my lord, is that it was given that power by agreement under the deed in circumstances where the limited partners knew what the intention was, knew the purpose of this. If the GP is given the power and the authority to conduct that business, which is specifically identified, it enters into the UK LP deed, where a distinction is drawn between, quotes, Cayman LP and Nugee. The effect of which we say is not to leave Cayman Limited as the only partner in UK LP. That's the only proposition I actually need to establish.
But you do need to establish, as I understand it, that Cayman, that the general partner, Cayman Limited, qua general partner of Cayman LP, by being given authority to enter into, well, to conduct the business of Cayman LP, which includes its only businesses to participate in this way. And so it's given authority to sign up to the UK LP deed, which it does. But what you need to establish is, by doing that, it had authority to make the limited partners, whether that's RBS or anybody else who happens to be a limited partner, a party to the contract constituted by the UK LP deed. That's your proposition.
Yes. In circumstances where the liability of each of those limited partners is limited by the terms of the Cayman LP deed.
Why should that be so? Why should they not be limited, if at all, by whatever the UK LP deed says? If they become limited partners in the UK LP deed, why wouldn't they be liable for something and be liable at any rate to put capital into it? It's a very odd situation that they have a liability, a ring-fence liability under the Cayman LP deed. But what liability, if any, do they have under the UK LP deed when they put no capital in?
Well, the way it worked was that Cayman LP was treated as having put in £100 into UK LP.
That's in the deed somewhere, is it?
It's in the deed of contribution, and then it's recognised in the deed. So the liability of any Cayman entity in the UK LP deed is limited to £100. The liability as between the partners in the Cayman LP is governed by the Cayman LP deed. I don't immediately recall what capital each of the limited partners put in, but let's just assume for the sake of debate it would be £100 rather than $100. You have to read the two together to work out the ultimate liability. But what is said against me is that only Cayman Limited became a partner. I say no, looking at the substance and the reality of the relationship in the light of the deeds, that's not true. So you are left in a world in which the partners, from time to time, in Cayman LP were in effect admitted as partners in UK LP by the reading to
As limited, so they're admitted as limited partners.
As limited partners. Now, I'm not sure anything's going to turn on this, but one needs to bear in mind that the Cayman LPD is governed by Cayman law, not English law. But I'm not submitting that there is any relevant difference.
Well,
Wait a minute, their liability, if any, in the UK LP would be done by English law.
Correct.
can we proceed on the basis that, save insofar as there are findings of fact as to the content of Cayman law is the same as English law?
Yes.
Yes. Because it certainly looks quite similar on the face of it.
Yes. My Lord may have also been asking me who had the power to admit partners in the UK limited partnership.
I wasn't, but that is another question.
Well, it's in section 6 of the LPA 1907, and it's section 6.5d. This is Authorities Bundle, tab 2, page 23. A person may be introduced as a partner without the consent of the existing limited partners.
Well,
That's
wait a minute.
one way in which the LPA is different to the 1890 Act. So one needs to compare and contrast.
No, I think, Mr. Peacock, you've got to start with the opening words of subsection, for section 6.5, subject to any agreement expressed or implied between the
Yeah,
parties.
and I'm not seeking to
And
ignore
clause
those
20, I think it is clause 20 of the UK LPD deed is an agreement between the partners, and it requires a deed of adherence.
Yes, and I'm not contending otherwise, my Lord. I'm just pointing to the rule that specifically applies to limited partners.
The deed of adherence that you require to admit a new partner, does that have to be signed by all the existing partners or only by the incoming partner and the general partner of UK LP?
The latter.
What a specimen deed
I think we do.
back of the document.
Looks like page 54 of Supplementary Bundle A. That's
So
the
yes,
right
page
one.
54, so it's just the further limited partner who needs to sign up. Need covenants with the partners for the time being to observe and perform the terms and conditions of the agreement and so forth, and is required to make a contribution in cash.
To finish off the submission, my
Yes.
Lord, under the Partnership Act 1890, section 24, subsection 7, that provides no person may be introduced as a partner without the consent of all existing partners.
Well, that is what one would expect because partnership is a relationship between people. You can't ordinarily be forced into a relationship with someone without knowing about it. But the Limited Partnership Act does give the power to the general partner subject to agreement to the contrary to admit new limited partners.
Yes, and that is one of the respects in which the LPA 1907 is different. I was dealing with the points the revenue make in this guy's argument. They make the point that Filed was not admitted into the UK LP when the assignment was made by RBS. And that's true, there is no formal admission of Filed. But if I'm right about what is meant by the agreement to admit Cayman LP, then that doesn't matter. And then lastly, the revenue have a point about a failure to notify. And the argument here is, well, you failed to notify that RBS was a partner in UK LP, and you failed to notify the registrar that Filed became a partner in UK LP, if I'm right. And that offends the registration requirements of the Limited Partnership Act 1907. And they say, well, the effect of that would be to make limited partners into general partners, and that can't have been intended, and therefore that's a pointer or a powerful factor that pushes away from the conclusion that you did intend to And the LPA in force at the relevant times, this is either 2007 or 2008, required the identification of the limited partner who contributed a sum of capital, section 4, required registration in accordance with the Act, that's section 5. This is tab 2 of the authority. And section 5 provides, this is page 21, that in default of registration in accordance with the provisions of the Act, limited partners are general partners.
17.
Page 21, tab 2, section 5.
Yes.
And then it is also said against us, section 8, page 28, you have to register the full name of each of the partners, that's 8D. And then section 9, page 30, requires notification of a change of partners or the name of any partner, 9(1)D. And it is common ground that there was no notification of RBS as a partner, nor any notification of Philed becoming a partner. The register at the outset refers, as it does even today, to Cayman LP as being the partner. Sections 8 and 9 of the LPA 1907 require registration of the partners at the outset and notification of changes. But section 13 of the Act, this is page 32, behind tab 2, provides for the register to send a certificate of registration and this was done here in the name of Cayman LP.
Sorry, what do you mean? It was done.
There was a certificate of registration was sent. Registering as a partner in the UK LP, quotes Cayman LP.
Oh, I see. This is not a certificate of the registration of the LP. This is a certificate of the registration of Cayman LP as a partner.
Yes.
The LP.
So if one looks only at the register, what one sees is a reference to Cayman LP. Now, we say if we're right about what is meant by that reference to Cayman LP, then there has been no want of proper registration. That's my first answer. Second answer is to say, well, even if that's not right, and it might mean that what were thought to be limited partners are in fact general partners, that's not actually a question before this court. What one has to look at is what did the parties in fact agree, whether the effect of that is to make limited partners into general partners is neither here nor there.
How is it said that the limited partners become general partners?
It's section 5, page 21.
But that's registration of the partnership, not registration of each partner.
Well, look, there's some case law that we haven't included in the bundle, though it is referred to in Lindley, where it is an open question, because it's only been decided over as to whether an initial correct registration of a partnership which is later followed by a failure to register a change of
Yes.
partner, offends Section 5 because you haven't registered in accordance with this Act.
I see.
And there is obiter comment to the effect that you ought to read Section 5 in that way.
Yes.
I'm assuming that that's right against me.
Yes. But you say it doesn't matter because that's not the issue before us.
Correct.
You want to say that Piled became a limited partner in UKLP.
Yes.
If we look at Section 4, we find that limited partners are those who shall, at the time of entering into the partnership, contribute a sum as capital. What sum, if any, did Piled contribute to UKLP, which is the partnership we're now talking about?
My answer is in two parts. Piled did not contribute any amount directly to UKLP. Cayman LP, through the GP, contributed an amount to UKLP
Back in the day when it joined up.
when it joined, and Piled contributed an amount under the Cayman deed to the Cayman LP. Now, if I'm right about what is meant by Cayman LP, then we say there's no offence to Section 4 because you treat the contribution by Piled to Cayman LP as being made in effect to UKLP.
But it doesn't, suppose it's $100. If the $100 in 2007, Cayman LP contributes £100 to UKLP and is admitted as a special limited partner. 2008, RBS's interest is assigned to Piled. You say Piled becomes, from then on, a limited partner in UKLP. And in answer to my Lord's question, you just said that Piled contributed to Cayman LP, let's say $100, in 2008.
It in fact took over the contribution that had been made by RBS.
Oh, I see. It didn't pay any more money in itself.
It's the deed of assignment. Bundle B2, tab 30. Clause 2, page 460.
Because it takes over RBS's interest, partnership interest in Cayman LP, it doesn't need to contribute any more to Cayman LP. It doesn't put, it obviously pays cash to RBS, but it doesn't pay cash to Cayman LP. It doesn't have to contribute any more. It just inherits RBS's position. Is that right? You say it therefore also inherits RBS's position, which you say it had under the UKLP.
Yes. And it is $100, we can see on the table on page 462. So we say there's no fundamental objection from the registration requirements of LPA 1907 that dictate the answer here as to the proper construction of the deeds. So there's nothing that helps the court in that regard. The last point that I need to address on issue 1A is whether there's any relevant difference between the LP period and the LLP period.
Now, is this the point that HMRC object to your running?
Yes and no. They think we're making a different point to the one we're making, so there is in fact no valid objection. We'll then try and apply to put in a supplementary skeleton. We have no objection to him doing it. We don't accept the contents nor his rationale as to why it's late, but we've no difficulty in the full reading. So I don't want to get bogged down in that. Perhaps if I explain it this way, that issue 1A is concerned with the contention that Cayman Limited is taxable on the profits, notwithstanding the allocation to finance. The relevant UK entity was a limited partnership until the 30th of November 2008. And thereafter it was an LLP. There were 3 allocations of super profit. One was in an LP period, and 2 and 3 were in the LLP period. That's a point I made a note of. Our case below, and indeed our case now, is that there is no relevant difference in the result of issue 1A, whether one looks at the LP period or the LLP period. So as a matter of law, if I'm right about general principle, or at least on the terms of the documents entered into, we invite the court to arrive at the same conclusion, irrespective of whether the underlying UK entity is the LP or the LLP. Our case below and here is that strictly one is applying different legislative provisions. In the LP period, you're concerned with the 1890 Act and the 1907 Act and the Common Law of Partnership. In the LLP period, you're concerned with the LLP Act. So we have a minor criticism of the Upper Tribunal that it doesn't appear to have addressed the LLP Act, but it's not an error that leads anywhere, because we say you arrive at the same conclusion, and we say the Upper Tribunal arrived at the wrong conclusion for the same reasons.
Did the Cayman LP adhere to the LLP?
I wanted to show you, my lord, the sequence of events. We've seen the UK LLP deed. There is an LLP agreement in Supplementary Bundle A, tab 12. That was entered into with effect from the 1st of December 2008. Page 204, and the party to that agreement, page 205, 3 down, is described as Cayman LP. Then it's page 210, party 31, is Cayman LP acting through its general partner, Cayman Limited. again, a distinction is drawn between Cayman Limited and Cayman LP. One looks on page 217 at the definition of members. Second line, the reference there to members is BCMC, which if one goes back to page 210 is Cayman LP. And then my lord asked about the signature on the earlier LP agreement.
But back in the definition on page 210, says the partnership acting through its general partner Cayman GP. That's Cayman Limited, presumably.
Yes, but the reference in the first line of Party 31 is BCMC, meaning the Cayman LP.
Yeah.
So again, a distinction is drawn between Cayman LP and its GP. And what you see admitted as a partner and admitted as a member and treated as a member is Cayman LP. And then the signature page as regards Cayman LP is page 281.
Yes.
And then if one just turns up bundle B3, I'm sorry, that's a wrong reference. We can see it at A12.
Sorry, where are we going?
Lord, I'm giving you a wrong reference. No, we don't need B3. A12 will do. I've made the point that I need to make there about Cayman LP being the member. And Lord Justice Nugee asked me this morning what was the state of play at the point that Phyled became a partner in Cayman. Well, by the time this agreement was signed, Phyled was a partner in Cayman.
You said this was dated 1st of
December.
Where do we find it? I can't find the date on it.
Top of 209.
Yes, thank you.
Yeah.
And earlier in 2008, the assignment had taken place.
Yes, that was 11th of June 2008. That's bundle B2 tab 30. So, if it's material, by the time the LLP agreement was signed, Phyled was a partner.
Yes, so if Cayman LP means the partners at the time of execution rather than the partners for the time being, Phyled was a partner at the time of execution of this deed, although it was not
The early one.
the only one.
Yes. Now, the revenue have a point about the LLP agreement, and one needs to turn up the LLP Act, which is in the first bundle of authorities, tab 9. 2, page 76, requires the incorporation document to identify the name and address of the persons who are members. 2.2e. And section 4 provides for persons to be members, page 79. Section 9, page 83, requires the registration of membership changes. And then section 18 defines name and address, address first and then 10 lines down name, in relation to an individual or a corporation or a Scottish firm. So it is said against us that that is a clear indication that a partnership without a separate legal personality can't be a member of an LLP.
Is there not a definition of person in the Interpretation Act?
There is. And that provides that it's a body of persons, corporate or incorporate. That's in the schedule to the 78 Act, unless there's a contrary intention.
I see.
And it is said against us, well, that is a contrary intention of section 18. And that shows that a partnership without legal personality can't be a member of an LLP. And there is debate in the commentaries as to whether that is right. So I shan't bother turning it up, but if you look at there's a work on LLPs written by Whittaker and Mitchell, that's in the authorities bundle at tabs 68 and 72. They are not convinced by this argument based on section 18 to the effect that a partnership without legal personality can't be a member of an LLP.
What is said to be the consequence that flows if the Commissioners are right on this point?
It would mean in the LLP period, whoever's right in the LP period, the LLP deed can't be taken at face value where it purports to record Cayman LP as the member. You have to give effect to that in light of the LLP Act. And the Commissioners say, therefore, only Cayman Limited is the member. And our answer is twofold. One is you can't spell out of section 18 that conclusion. But B, even if you get down the line of that logic, you can't simply assert that only Cayman Limited is the member. Now again, for what it's worth, section 3 of the LLP Act,
Where does section 18 bite on the substantive provisions of the Act, apart from section 9?
it's section 2.2.
2.2.
2.2e.
Oh yes, name and address of each person.
Now there's one provision in the Act that was, I'm afraid, left out of that clip of legislation, so one needs to turn up. There's a very thin supplementary authorities bundle. Tab 1. Section 3, subsection 4, where the register delivers a certificate, that is conclusive evidence that the requirements of section 2 have been complied with. And here, it's not in the bundle, but there is an LLP certificate recording Cayman LP as the member. Right or wrong, that was done. But on the face of it, that's conclusive evidence that the requirements of Section 2 were seen by the registrar to be satisfied. Now, in a sense...
Isn't that the point, sorry, Mr. Peacock, isn't that the point that the HMRC challenge you on, because they say that that piece of evidence is something that hasn't really been investigated? That's the new point, isn't it?
No, the new point is they point out that in our application for permission to appeal, we made some arguments, Mr. Ganny made some arguments in paragraphs 19 through to 25 about the difference between the LP and the LLP period, and the Upper Tribunal were not to be taken to have given us permission to appeal on those. But this particular point about the effect of the certificate was not identified in those paragraphs. So my learned friend has a point that the certificate's not actually in evidence.
No.
But
he says it was wrongly granted, I think, doesn't it? Anyway, so it's uninvestigated. We haven't got it in evidence, and I don't think we've got any findings about it, have we?
we don't.
No, okay.
We don't. But if one does what I did last week and just look on Company's House, it's there, right or wrong. But the point for which we said we don't have permission to appeal is a different point, which is, can we make anything of the difference between the LP period and the LLP period? And that misses the point. We're not trying to make any difference. We're saying you arrive at the same answer by strictly a slightly different route, because you've got to look at the two sets of legislative provisions. But we're not making any point about that. So we're not...
Well, you are in a way. I mean, if you're wrong about what Cayman LLP means in the UK LP deed, and it only means those who were partners at the time of that deed, those partners did not include FILED, and one allocation of super profits was made during that period to FILED, who didn't sign a deed of adherence. But you say, by the time the LLP came into existence, FILED was a partner in Cayman LP, so that even if you adopt a more restricted meaning of Cayman LP in the LLP deed, as meaning those who were partners at the date of the LLP deed, FILED gets in, because it was by then a partner. So I think you are, at least on one set of arguments, differentiating between the LP period and the LLP period. Are you not?
I am saying that there is a difference, but I'm not saying that matters because I'm right for a logically prior reason.
Well, I follow. You say you're right for all sorts of different reasons, but if this argument matters, then there is a distinction between the two periods.
If it matters, then there is a distinction. But is that a contention for which we don't have permission to appeal? Then I say no, it's part and parcel of the arguments that we clearly do have permission to appeal. Murphy also has a point about our skeleton argument being too long. I'm going to ignore that, unless the court tells me otherwise. That's what I need to say about issue 1A. The last of the issues I need to open on is issue 5. And this, in many respects, is much simpler.
This is for the purposes of a trade.
Yes. So, to set the scene, it's common ground that the only issue now is not the entitlement to a deduction for the interest, but whether the interest debits are trading debits or not. The relevant features of the landscape for that debate are that Cayman Limited is treated as carrying on the UK LP's fund management business, and doing so through a permanent establishment in the UK. Cayman Limited was the borrower from RBS under the facility agreement. Cayman Limited has an obligation to pay interest. Cayman Limited is entitled to relief of those interest debits under what was the Finance Act 1996, now the Corporation Tax Act 2009 Part 5, that's the Loan Relationship Code. Loan Relationship Code draws a distinction between trading and not trading. And it's going to turn on the application of section 297. Quickly turning up that legislation, it's behind tab 16.
Can I just go back a step? You said Cayman Limited is treated as carrying on the UK management business. It's being treated as deriving taxable profits out of it, but is that the same as carrying it on, bearing in mind, not least, that it's only a limited partner in the UK management business, and does it matter?
It is treated as carrying it on by virtue of the provisions that make partnerships transparent.
Right.
I can show you in a moment.
Even though it's a limited partner?
Yes.
Right.
No distinction is drawn between limited partners and general partners. Right. So by force of statute, you look through the partnership and the partners are treated as carrying on the underlying business. And perhaps just as the court has this, it's tab 21 of the first volume of authorities. These are the 2009 provisions, but they were in like effect in the earlier code. So it's section 1258 before the page 129. The firm is not to be regarded as an entity separate and distinct from the partners. And then 1259 tells you how to compute the firm's profit and losses. And then 1262, page 131, tells you to allocate the firm's profits and losses between the partners in accordance with the firm's profit sharing arrangements. That's defined in 1262(4). And the effect of that is that if you're carrying on a trading partnership, then what the partners get is a slice of trading profit. And the equivalent rules for LLPs are at 1273, pages 136 and 137. So coming back to the loan relationship provisions, this is tab 16, page 116. Section 292 identifies the part, sets out how profits and deficits arising to account from loan relationships are brought into account. And then 292 sub 3 directs you to 296, 297 onwards for different facets of that code. And then over the page 295, profits on a loan relationship are all chargeable to tax as income. So you don't have the income capital divide in loan relationships. And 296 says that the profits and deficits are to be calculated using the credits and debits given by the Act. So it's a statutory credit and debit that allows you to work out the taxable profit. And then 297 tells you to bring in trading credits and debits under Part 3 of the Act. And in effect, if you've got a trading credit, if you've got a loan relationship credit, that's a trade receipt, that's 2972. If you've got a loan relationship debit, that's a trade expense, 2973. 2974 tells you to ignore the capital rule and the wholly and exclusively rule and a special rule about patent royalties. And then 2981 tells you that for the purposes of a creditor relationship, so you're the lender, you're a party to that relationship for the purpose of a trade only if it is party to the relationship in the course of activities forming an integral part of the trade. So if you're a creditor, it has to be an integral part of your trade, whereas there is no equivalent rule for debits. And then 299 provides the charge to tax on non-trading profits. And then 300 tells you how to bring them into account, and we're not concerned with 300 or 301. But the important points to note are that you have to determine, in the language of 2971, whether you're a party to a loan relationship for the purposes of a trade in each accounting period. So it's an accounting period by accounting period test. So the points we make in addressing the first tier's decision at paragraphs 207 to 211 and the Upper Tribunal at paragraphs 142 to 166 are set out in our skeleton argument at para 86 and onwards. But we say there's no wholly and exclusively test here. We're not concerned with whether it's capital or income. You're not required to demonstrate that it's in the course of something that's integral to your trade. It's a debit rather than a credit. The only relevant question is, are you party to it in that period for the purposes of the trade? So there are a series of higher hurdles to be satisfied, either elsewhere in the tax code or here as regards creditor relationships, that are not relevant to this question. So what do we know? We know Cayman Limited borrowed to acquire the 19% stake, which it then contributed down to Cayman LP on terms. In each accounting period thereafter, Cayman Limited is treated as carrying on the fund management trade of UK LP in part. And we know that Cayman Limited borrowed the money in order to acquire the interest so as to be a partner. We say that, on its face, satisfies the terms of section 297 subsection 1. Now what the first tier said was, well, Cayman Limited borrowed to acquire the 19% stake so as to be a partner in UK LP. That's true. The first tier then said, well, Cayman Limited didn't carry on the trade before it acquired the 19% stake. That's also true. The first tier then failed to give effect to the relevant statutory provisions, which is once it had acquired that interest, it was treated by the statute as carrying on that trade. By virtue of which it derives profits that are taxable in its hands as trading profits. And the Upper Tribunal seemed to think that the acquisition of the interest in the partnership, prior to which Cayman Limited didn't carry on the trade, was conclusive as to issue 5. That's what they say in their paragraph 157. And we say that's not an answer to the statutory relevant question. So in consequence of acquiring the interest, Cayman Limited is treated and is taxed as carrying on in part the trade of UK LP.
We are concerned, is right, with whether Cayman Limited can deduct payments made in satisfaction of the loan, either interest or capital.
Just interest.
Just interest. So the point you were making about it doesn't matter whether they're interests or the interest capital rule doesn't apply, doesn't matter here. So we're talking about an interest which Cayman Limited is paying on the money it borrowed in order to acquire the 19%.
Yes.
And you say that is a question which must be looked at accounting period by accounting period, so that even if Cayman Limited wasn't carrying on the trade when it initially borrowed the money, it is nevertheless paying the interest during a period in which it is treated as carrying on the trade.
Yes. Because the statutory question is, why are you a party to the loan relationship in this period? Now, what the commissioners say is, well, Cayman Limited borrowed to acquire the partnership share, but because it paid the vendors, the sums that it borrowed don't advance the trade of the partnership. And we say, with respect, that's not the relevant statutory question. It has to be for the purposes of the trade, in a world where you're deemed to carry on the trade, or treated as carrying on the trade, in consequence of having acquired the interest. So to say that the monies you borrowed didn't go into the trade, but went to the vendors is true, but not relevant. The commissioners also say, well, it's helpful here to look at cases on the wholly and exclusively test. The court will no doubt have seen this many times before. There is a rule computing trading profits that you can only deduct expenses that are wholly and exclusively incurred. And those cases, by and large, record that you have to demonstrate that the expense is for the purposes of the trade. It's put in slightly different language depending on which authority you look at. But those cases are not relevant here because we're not asking the wholly and exclusively question. So my own friend points to some old cases called Anglo Brewing and Strong and Woodyfield. A more recent case, judgment of this court in a case called Vodafone, or Justice Millett, but what is meant by wholly and exclusively incurred. None of those cases are directly relevant because we're not concerned with that statutory formulation. Instead, as we understand it, the thrust of the case against us is this, that if you'd borrowed to buy some trading assets, that would be for the purposes of your trade. Or if you'd borrowed to capitalise a partnership in order to buy some trading assets, that would be for the purposes of your trade. But where you've borrowed to acquire an interest in an existing partnership, where brackets the money goes to the vendors and not to the partnership, that can't be for the purposes of your trade. And we say that is an unprincipled distinction for which there is no authority. The relevant question is, in the language of 297 sub 1, did you borrow this money for the purposes of a trade? If you borrowed it to buy a trade, the profits of which you are taxable on in this accounting period and the next one, the one after that, then it is for the purposes of your trade. Now there are three authorities which the court ought to see, one of which we looked at already, that don't actually answer this question, but they get close. So the first is Major and Brodie, where, this is volume 2, tab 40, that was a question of statutory interest relief. So, as an individual, prior to 1969, there was no mechanic by which you would necessarily get interest relief. And from 1969 onwards...
Sorry, where are we going? Bundle?
Major and Brodie, volume 2, tab 40.
Yeah. Oh, yes.
Statutory interest relief, under what was then section 362, those provisions came in 1969 to give individuals interest relief. So what the judge had to decide was, were Mr. and Mrs. Brodie entitled to interest relief? Did they meet the requirements of section 362? Answer, yes. And the judge arrived at that conclusion in circumstances where they'd advanced capital to one partnership that had been advanced to the second one and had carried on the trade. But Major and Brodie doesn't answer our question because it's concerned with individuals seeking statutory relief. Second case, this is volume 3, tab 55. It's a case of Vanes. Decision of this court in 2018. Mr. Vanes was a solicitor, so he carried on a profession as solicitor on the tax bench. And he was required to make a payment to settle the debts of his former partnership. The partnership got into difficulty, they owed bank debt. He was called on to make a payment to the old partnership lender, and he sought to deduct that from the profits of his new partnership on the basis that it was wholly and exclusively incurred for the purposes of his earning profits in the new partnership. And that argument was rejected. The payment he made was not incurred wholly and exclusively in earning the profits on which he was charged. So this is not a case involving statutory interest relief for individuals. It is a case about deduction of interest by a trader, but it's not a loan relationship case. So the reason Mr. Vanes failed was he failed to meet the whole and exclusively test. So again, it doesn't answer our question. And then the third case, volume 3, tab 58, case of Shiner. It's a rather complex case, but in outline it was this. Mr. Shiner and Mr. Shineman set up life interest trusts, one each, and they borrowed money to put into a partnership where the partnership carried on a trade. And they sought to deduct the interest against their trading profits from the partnership. And they lost. And the reasoning one can see, if one turns to paragraph 32, there's a question of who was the loan made to and by, and that's answered page 800, paragraph 32, the loans were made to the life interest trusts and not the partnership. So that then gave rise to the question, which is discussed paragraph 35, page 803. Which was, were they entitled to any interest relief on amounts that they contributed as life tenants into a partnership? And the judge said, no. There's no statutory basis for that. And that then led to the second question, page 805, paragraph 45 onwards, which is whether a loan taken out to put capital into a partnership can satisfy the wholly and exclusively test. The judge said no. Because the judge said there's a conceptual difference between the partnership borrowing money or a partner lending money to a partnership, either of which might meet the wholly and exclusively test, and on the other hand, borrowing to put capital into a partnership which can't meet the wholly and exclusively test. So Shiner is an example of a case where the partner sought to deduct interest incurred in contributing capital to a partnership, where the contention was that interest was deductible on a wholly and exclusively basis as an expense of the trade. Court says no. But again, that case doesn't answer our statutory question here, which is where you borrow money as a partner to acquire an interest in a partnership by virtue of which you carry on a trade, have you thereafter borrowed money for the purposes of the trade? My answer is a simple yes. I started perhaps 20 minutes ago. That is an inevitable consequence where you buy an interest in a partnership that carries on a trade, and you are going to be taxed on the trading profits that you receive. It really is a very simple question, we say, with a very simple answer. So the revenue were wrong to draw any distinction of principle between acquiring trading assets on the one hand and buying an interest in a partnership on the other. There is no such difference of principle for the purposes of section 297. I'm afraid the Upper Tribunal and the First Tier Tribunal have just got that wrong. So, for now at least, I don't propose to say anything more about issue 5. Always tempting fate, but that may be the more simple of the issues, of course. There is a debate between us on issue 2, and that's my own friend's respondent's notice. So unless there's anything else I can help the court with in opening, I'll sit down.
Thank you very much, Mr. Speaker. My Lord, you'll see that in our skeleton argument we've set out in some detail how the basic underlying regime of the partnership taxation works. We say that's relevant to both the issue of who is taxable on the profits and the issue of deduction. So it really lies throughout this appeal behind the statutory questions that you've got to grapple with, because what you have to do is this three-stage process. We're really only interested in the first two stages. What the legislation requires is that you have to compute the profits of the trade being carried on in the partnership. And here, the trade that is being carried on is the investment management trade being carried on by the UK Limited Partnership or the UK Limited Liability Partnership. And it's the profits of that activity, that trade, which the Act is seeking to tax. So once you compute the profits of that investment activity carried on by the UK LP, that figure then has to be allocated to the partners of the firm. That's the second stage, and that allocation has to be made in the language of section 1262 of the Corporation Tax 2009, in accordance with the firm's profit sharing arrangements, which requires you to look at the rights of the partners of the firm. So that gives rise to the first issue. Well, who are the partners of the firm to whom the profits which you've calculated have to be allocated? And the effect of that regime is that for tax purposes, the firm is transparent. You have to look through the firm to find the partners, the legal persons who are liable for tax on the firm's trading profits. But the revenue say that's where the transparency stops. Once you have identified the partners of the firm, and once you have found the persons to whom the profits are to be allocated, then the allocation process for that partnership has had its effect. The profits have been allocated, and the persons to whom those profits are allocated are liable. The regime does not then look through the partners of the partnership you're looking at. They don't look through the individual or corporate partner to whom the allocation is made, so as to trace through the profits into any other arrangements the partners have entered into in respect of those profits.
So if it were a sub-partnership, I suppose, you say that it's the partner in the head partnership, so to speak, who is liable for all the tax. What do the sub-partners pay, if anything, by way of tax?
Well, that will depend on the arrangements entered into in the top partnership. So,
take one of the examples you've given in the cases, or that's old House of Lords case, where A buys the partnership interest of B, and it's an existing partnership, and there is a sub-partnership of a share in the partnership. So on your analysis, you stop at the head partner.
Well, if there's a case like this where you have two businesses and two partnerships,
Yeah.
so you've got to allocate the profits of the underlying profit to the partners, and then the partner who gets allocated that profit is the sub-partner. So they are taxable in full for the profits of the trade of the lower partnership. If that sub-partner has then entered into a further partnership sharing arrangement with other partners, then that is a separate partnership with separate profits being allocated to those separate partners, such as Phylid in the present case. But Phylid is not being taxed. If you have, as in the present case, two distinct partnerships, and this was deliberately structured to be set up so that the Cayman Limited Partnership had its own business, and it was designed to have its own business of investing in a lower tier partnership and becoming partner in that lower tier partnership, then you have created two businesses with two potential profit streams. In the present case, because the limited partnership is in the Cayman Islands, and because Cayman Limited is a Cayman Limited Partnership, there is no further tax charge on the Cayman Limited company. It's just receiving a further profit allocation from a non-resident partnership. So Cayman Limited is only taxed in respect of its allocation, profit allocation from the UK partnership. But why this is unusual, and this is an unusual structure, as the Upper Tribunal said, is because of the particular arrangement that has been put in place in the present case.
Suppose Cayman LP was in fact an English LP. Then what would happen? On HMRC's case, the share of UK LP, which is allocated to Cayman LP, now hypothetically an English LP, is taxed in Cayman LP's hands. Then what happens when Cayman LP allocates those profits amongst the partners in Cayman LP?
Well, assuming that it's another UK limited partnership and the other partners are UK resident, then those other partners would be taxed on their share of the top partnership. They're not taxed in respect of a redistribution of assets of the lower partnership. They're taxed because they have entered into a separate partnership.
So is there a danger of double taxation?
There is an economic taxation, double taxation in a sense, because there has been a full taxation of profits at the corporate level. But that is because there have been two businesses, in the same sense that if you have a chain of corporates that are actually non-transparent and are taxed with profits flowing up, then there can be more than one level of taxation. But that is the consequence of this structure being devised, under which we have a top partnership with its own separate business of investing in a lower tier partnership. So we have, you analyse this in one of two ways. It's either one large global partnership, in which case it's all transparent and you look through, because all the partners have become partners of the single UK partnership, or, as we see it, there are two partnerships. There is a UK partnership carrying on its trade, and the profits of that trade have to be allocated to the partners of that trade. And then there's a higher tier partnership, which has profits which, unsurprisingly, represent the same profits as the lower tier, because that was the business model that they set up to do. And so one stands back, why did they do this? Why was this balancing act entered into, where you had to have the partners in Cayman one step removed with their own partnership from the UK partnership? Well, that's explained by the arrangements that were put in place with the TRS. This was an idea that was put in place in order to enable the Cayman Limited to pay off its capital borrowings using profits that in effect had not been taxed. Because instead of being allocated to Cayman Limited, being taxed in Cayman Limited's hands, and then it pays off its borrowings, including its capital borrowings to the Royal Bank of Scotland. Ordinarily, if you borrow money and your source of of money to pay off your borrowings is a taxable income, you pay tax on the income that's allocated to you, or tax on your trading income, and then you pay off the borrowings out of that taxed income. But here, this special structure was put in place in order that profits could be allocated to the financial trader, RBS or FILED. FILED can get a deduction. This was the idea for the monies it paid under the TRS to the Cayman Holding Company. It's in the Cayman Islands, so it's not taxed on that monies. And then the Cayman Holding Company puts the money back down as capital contribution to Cayman, which then pays off the debt. So the unusual structure in this case is explained by the unusual arrangement that was being entered into. So what we say is that structure was always envisaged as being unusual because it involved going into a partnership with the Royal Bank of Scotland. You didn't just go out and borrow money from the Royal Bank of Scotland. You needed to do something different. So they went into partnership with the Royal Bank of Scotland, but the Royal Bank of Scotland did not become, and was not intended to become, a direct partner carrying on the investment management business in the UK. The Royal Bank of Scotland was put into this distinct partnership with a distinct business in the Cayman Islands. And from the outset, that was envisaged as being the steps that were necessary to take to produce this hoped for, very advantageous tax result of being able to pay off your borrowings out of income that hadn't been taxed. Now, so I think one does need, when one's looking at the overall intention of the scheme and what the parties were trying to do, and why does this arrangement look like it does, you do have to remind what was being achieved, sought to be achieved here. And I think the best description of this, there are two.
It was in the DOTAS document, wasn't it?
There's two documents. There's first of all, there's the contemporaneous proposal deed drafted by Ernst and Young, which is
That bundle A, tab 1.
supplementary bundle A, yes, tab 1, right at the beginning. So this is on page 3. It's dated the 5th of July 2007. So it's just the day before the transaction was sort of implemented. So it summarises the background that a learned friend has explained of how an entity needed to be set up in order to acquire Mr. Reeves' share, plus the other partners who wanted to reduce their share, Sugar Key and Mr. Platt. So we needed to have a structure of some kind to put in place to receive that. And the structure that was chosen was to have a separate vehicle as a partner. But if that's all that had happened, and that you'd had an acquiring vehicle put in place, which had to borrow the money to buy out Mr. Reeves, then that person would have had to have been allocated profits, which it would have paid tax on, and it would then have had to have paid off the borrowings, as usual, out of its tax profits. So this, the planning that was devised by BlueCrest's accountants, was intended to get a better result. And in order to achieve that better result, the idea was for the Cayman Limited, the acquiring company, to go into partnership, separate partnership, with the Royal Bank of Scotland. So that meant that what happens is that the lender, the Royal Bank of Scotland, could, if there were super profits, be given the share under the terms of the Cayman Partnership deed, should be given a profit share, and then that profit share would be paid off in the financial traders' accounts as a deduction under the TRS arrangement. So it made a profit equal to whatever turn it made a margin on the TRS, but the substantial amounts of the profits allocated to the Royal Bank of Scotland were paid round to holdings and back down to the Cayman Limited, who then could pay off the debt to the Royal Bank of Scotland and all the loan notes to the traders. So that's what they were trying to achieve. And at paragraph 7 to 13 of the structure summary sets out what we've seen, how the basic structure was set up, with the new distinct limited partnership being established. And at 14 and 15, we're getting to how the LP was intended to operate, and how the other partners were intended to relate to the underlying partnership. As it says that the general partner, that's GP here, is Cayman Limited, who contributes the interest in BCM LP, so that's the interest which it acquired, to the new Cayman Limited Partnership. Then, as a result, LP will become a limited partner with an income and capital interest in BCM LP. So the idea was that the Cayman Limited Partnership would become a limited partner. At 15, then it said new partners may in future be introduced to LP. LP will operate as a second-tier partnership, giving individuals the ability to share in group profits and to potentially benefit from capital appreciation without being directly introduced into BCM LLP. And so, as we've seen, how that was implemented in the draft was under the terms of the limited partnership deed, the Cayman Limited Partnership deed. We have this new business being created, and we saw at page 75 of tab 3, page 75, we've seen at clause 6 that the partnership's business shall be to invest in an investment management business through being a limited partner in BCM LP, and the business shall be construed accordingly. So we have a separate activity, a separate business being carried on in the Cayman Islands. But of course, we've observed that there are similarities between Cayman law and English law, and in particular in respect of what limited partners can or can't do, and that's reflected in the Cayman deed itself. On page 83 we have clause 18, which said that the general partner has the exclusive responsibility for the management and control of the business, and 18.2, the limited partners shall take no part in the management, control or conduct of the business. So the business of this partnership is to invest in an investment management business through being a limited partner in the underlying UK LP, but the limited partners shall take no part in that business. So they wanted to ensure that RBS would be able to be allocated profits in order to enable it to participate in the TRS arrangement. But they did not, for whatever reason, include RBS as a partner in the investment management business in the UK. The structure was to have this separate business. And so that's the rationale for the structure. as further explained in the DOTAS agreement, in DOTAS notification, which sets out in a little bit more detail how the tax basically was seen to work and what the advantage of that. I don't know whether you've seen the DOTAS. I mean, it's quite helpful just to have in mind how it was perceived that the Royal Bank of Scotland would be taxed under.
Yeah.
under
Well,
this
the
arrangement.
DOTAS form said that the structure enables pre-tax income to be applied to fund repayment of the debt.
Yes. And how that was achieved and why it was necessary for profits to be allocated to Royal Bank of Scotland was that was intended to reduce the allocation that Cayman Limited got, and the Royal Bank of Scotland would, when we come to the Ramsey, we'll look at this in more detail, but the Royal Bank of Scotland was committed to paying on the allocation it got to Cayman Limited's holding company under the TRS, and Cayman Limited's holding company was committed to transferring the same amount of the funds down to Cayman Limited, and then Cayman Limited would use that to pay off the borrowing. Yeah. That explains this structure, which is unusual. We don't have many sort of sub partnerships. The structure for ordinary partnerships, where there are just large partnerships where you may see sort of sub-partnership arrangements, but they are all partners of a single partnership. They are transparent. One can look through the various partnership arrangements that all the partners of one single partnership has entered into and trace through to the partners. And one can do a similar thing where you have an entity which is tax transparent. For example, a limited liability partnership. That is, has legal personality. So a limited liability partnership can become a partner in an underlying partnership, but it's tax transparent. So you look through the limited liability partnership to find the partners at the end. But a sub-partnership is a hybrid. It is not, the sub-partner is not tax transparent. It may be that it looks like that, well, we didn't know precisely what the status of a Cayman limited partnership was, whether it was tax transparent or it was an entity or a legal person or not, until we had the expert evidence leading up to the First Tier Tribunal, where the experts agreed in that case that a Cayman limited partnership does not have tax transparency. So if you look at the original proposal where it was intended to be the partner, it doesn't really work in light of the Cayman evidence. So you have this entity, which is not a legal person, which has signed these contracts. And so that takes us to the first issue, issue 1A, as to what the effect of that is. Was it the Cayman Limited acting as general partner that became the partner in the lower tier partnership, or was it all the partners in the higher partnership? So that's a sort of introductory background to issue 1A. I said I made a misspoke saying that something didn't have tax transparency. Oh, that's it. Sorry, yes. On the status of the Cayman expert evidence, that came back before the FTT to say that a Cayman limited partnership does not have legal personality, nothing to do with tax transparency. So if I said tax transparency, that wasn't the expert evidence. It was what the expert evidence established, that a Cayman limited partnership is just like an English limited partnership in that sense. So what we approach issue 1A, knowing that the one person that didn't become a limited partner was Cayman Limited, Cayman LP. So then is, well, what does it mean when they entered into these agreements, under which mechanically step one, Cayman Limited becomes a limited partner in the underlying UK partnership, and then Cayman Limited contributes on its own account the interest it held to the Cayman Limited Partnership, who is really the partner in that scenario. And both the First Tier Tribunal and the Upper Tribunal, having looked at all the evidence, sort of concluded that the better view was that it was a sub-partnership, and that not all members of the Cayman Limited Partnership became, and therefore thereafter would become, members of the UK Limited Partnership. And we say that was essentially a question of mixed factor law, which the tribunal, First Tier Tribunal, was entitled to come to. It's looking at all the evidence, all the idea behind the structure, what the parties were trying to achieve, and how it related to the overall legal framework that governs LLPs and limited partnerships generally. So, but all this is a matter of, one starts from the presumption, this is a matter of statutory interpretation. We are looking here to see, for the purposes of section 12.6.2, what are the partnership sharing arrangements, and that requires you to identify at the outset, well, who are the partners who have rights to share in the profits to which this argument relates. So that's why I think 1A is the logical place to start rather than 1B. And in summary, I mean, we've set this out in quite a lot of detail in our skeleton, so I'm not going to go through all the points, but I will make the basic points here that the question for the FTT was a question of mixed factor law. The FTT did not misdirect itself in law. The FTT's conclusion was justified by the evidence on which it relied, and the FTT's conclusion was further supported by all the matters which were referred to by the Upper Tribunal as further supporting the idea that what happened here was a sub-partnership, and in particular the issues which have been raised today about what precisely was the authority that the Cayman Limited had to bind its other partners to the UK Limited Partnership deed. What was the capital contribution that they made to the UK Limited Partnership deed?
So if it's a question of mixed factor law and an appeal lies only on a question of law, unless either the Upper Tribunal or the First Tier have misdirected themselves in law, we can't interfere.
Unless they reached a conclusion which was just not open to them on the evidence.
That counts as an error of law, presumably.
Yeah. In my submission that the Upper Tribunal dealt with this more fully, and the First Tier Tribunal's conclusions are relatively shortly stated. I think one has to give the First Tier Tribunal some credit, because this was just one part of a series of issues. There was another sort of conceptually similar arrangement that the partnership had entered into in respect of paying bonuses through a special purpose vehicle. So the bonuses were allocated to the special purpose vehicle and then found their way to the individuals. It was a similar sort of route to the present case. So all that was going on. So the FTT's conclusions are relatively brief, but as the Upper Tribunal held, the basic approach that the FTT took, the job that it thought it needed to do was to evaluate whether the better view was that this was a single global partnership with all the members of the Cayman Limited having become members of the UK Limited Partnership, or whether the better view was that it was a sub-partnership such that only Cayman Limited became the actual partner. And I think the starting point from that does become what do they actually do in the agreements? Malone, for instance, well, it's a point of principle first of all, and then we can look at the details. But actually, particularly where you've got a limited partnership investing in another partnership, then to find some overarching principle, say that, well, if you see the name, if the limited partnership name appears on the partnership deed, then as a matter of law, that inevitably means that all the members of the partnership become members of the lower partnership which is joined. That's less easy to envisage with a limited partnership, because particularly where you've got rules such as the English rules and the Cayman rules, which expressly say that the limited partners can't conduct the business. If you've set up a business and your specified business is to become a partner in another partnership, and the limited partners can't conduct that business, then it is the general partner that has the authority to sign the contract. It may be doing it as agent, but it is the general partner that is the person with the capacity to go and join other partnerships, we would say.
Until the current edition of Lindley, which responds to the Upper Tribunal decision, the editor did put it forward as a proposition of law that the consequence of a partnership purporting to become a partner was that all the partners in that partnership became partners, and he drew no distinction between a general partnership and a limited partnership. So you have to deal with what the leading textbook says.
Yes, I mean, my answer to that is just too broadly stated a proposition, and that in every case one would have to look much more carefully at what happened. And we've seen it will depend on how people do things. I mean, we've seen the type of example given in the Major and Brodie case, where all the partners were named. It was a Scottish partnership, it's true, so that had a separate legal personality. But in a case such as Major and Brodie, where Mr. and Mrs. Brodie were joined, became members of the Murdoch partnerships, but they were named as parties, no one would doubt that they all became a single global partnership. And in a general partnership, it may be that it's easier to reach the conclusion of Lindley, or Lindley's first conclusion may be more properly stated. But I also rely on the fact that the current edition of Lindley cites the Upper Tribunal's decision as authority for the proposition that it's different if there's a sub-partnership without any dissent.
But again, no distinctions drawn between general and limited partnerships.
No. But whether one, I mean, I'm not making a proposition that is impossible for a limited partnership to become a partner, or all the partners in a limited partnership to become partners, but one would start from wanting to see in the limited partnership agreement powers that they do that, and they want to see them actually becoming partners or signing documents or doing something within the confines of a limited partnership agreement. We don't have that in the present case. What we do have is the steps that were actually taken, and all the documents that were actually signed were signed by Cayman Limited as the general partner. The machinery by which intended that the limited partnership would become a partner was that the general partner was the assignee of the share, and then it signed the deed of adherence at the outset, and then it contributed its partnership share to the limited partnership. One's got to work out what, on balance, what was the true effect of that. And of course, my own friend points to the limited partnership deed as saying that the Cayman Limited Partnership is the partner, and he says, well, that's shorthand for all the partners, whoever they may be. Whereas if you look at the limited liability partnership deed, where it was slightly more clearly expressed, and what it's shorthand for.
Well, we can't interpret the LP deed by reference to a much later document.
No, you can't. But what do the parties have in mind when they question is, what is that shorthand for? And one possible alternative that's rational is that everybody. That's what my learned friend's case is. But the other possible alternative of what it's shorthand for is that when it says Cayman LP, it means the general partner, or it means Cayman LP acting through the general partner, which is what is said in the later deed. The person that's doing the acting is the general partner, because that's the only person that can act for the limited partner. So that it is the only person that can do the business, and the business is becoming a partner.
Can I put a question to you that I put to Mr. Peacock? Are we dealing with some special partnership principle, or is this part of the principle applicable to contracts purported to be made by unincorporated associations without legal personality?
Well, I was seeing this as an argument on partnership. We've not relied on any further principles in this case. So whether we were right to do so, in light of your lordship's question, I'm not 100% sure, but we'll think about that overnight. But
I'm just wondering where this principle comes from. I'm wondering where this principle comes from.
The principle about
The one that Lindley states.
yeah. Well,
The rationale
Yeah.
seems to be that the partnership doesn't have legal personality, therefore all the partners become partners. But that rationale might be the same rationale as applies to any contract purportedly made with an entity without legal personality, such as a members club.
yes, I see that, but we've not approached this on anything else. But this is a sort of an issue of partnership law, and the closest that, as a matter of authority, we have to it is Mr. Justice Park's
Yes.
comment. But again, that if it is a principle, then I would say it just applies much more readily to a general partnership where everyone has capacity to act and do the business of the partnership, rather than a limited partnership where the partners' rights are severely they're limited both by the underlying law and the deed, and they require extra things to be done, such as the contribution of capital, because unless you can identify an amount of capital that a limited partner has contributed to the underlying limited partnership, how can they be a limited partner? And what is they are partners to the extent that they can be bound by the actions of the general partner of the lower tier partnership. But if they've not contributed any capital themselves, then it's very difficult to see how they're bound at all, and if they're not bound, how can they be partners? So, picking up my sort of procedural analysis, the question about mixed fact and law was dealt with by the Upper Tribunal at paragraph on page 150, paragraph 130, I'm not going to take you to the cases. I don't think it's was disputed by my learned friend that it is a question of mixed fact and law. The authority relied on was Heath, Spicer and Mansell. And we say that if so, that the documents are entered into the parties are relevant to that inquiry. But again, as Mr. Peacock accepted, the tribunal's also got to consider the substance of the matter and what the parties were seeking to achieve. And we would say that's all the more so in the case, whereas here, on the face of it, the documents purported to make Cayman LP a partner, but it wasn't a person that could become a partner. So you do have to look beyond the documents to try and see what the parties were truly trying to achieve. So on the FTT's approach, did the FTT misdirect itself in law? And at paragraph 35 of the Upper Tribunal concluded that the approach taken by the FTT was permissible, because what the FTT asked itself was whether this was on the one hand a sub-partnership, or whether all the partners in Cayman LP had become partners in the UK LP. So in the context of this appeal, where there are two identifiable partnerships, two identifiable limited partnerships that no one is suggesting that one of them doesn't exist or one of them doesn't have an identity, the FTT's approach was right. It had to judge this question as what was the effect of what they were doing, and was it a one single large partnership they created, or were there two partnerships? One being a sub-partnership, and there was no misdirection in law. And the third point is that the FTT's conclusion was open to it on the material it had before it. The Upper Tribunal at 66, paragraph 66, recognised that the First Tier Tribunal had adopted a legitimate approach and couldn't identify any points where the FTT had taken into account some irrelevant considerations, and so concluded that the FTT's reasoning was sound. And the Upper Tribunal was clearly mindful of the fact that on this mixed question of fact and law, the FTT had reached its decision, having examined the documents, heard the evidence as to what the parties were seeking to achieve. But then, more importantly, the FTT's conclusion is, we say, supported by all the further and more detailed reasons given by the Upper Tribunal. The Upper Tribunal was right to say that whether a partnership exists, and so if so, who the partners are, does involve looking at the substance of the matter. So it's not simply a question of looking at the documents. And the Upper Tribunal took into account the matters of form and substance, which they discussed at paragraph 50 of the Upper Tribunal decision. So just in summary, we say that these all support, gives further support to the FTT's conclusion. So that's core bundle 7, tab 7 at 162. this is looking at that basic analysis of the Royal Bank of Scotland. And at 50, the points made by the Upper Tribunal is that it was not named as a limited partner in the amended, restated UK partnership deed. It made no capital contribution. No allocation letter was issued it under Clause 11, and it didn't execute a deed of adherence. My learned friend makes the point, well, that doesn't matter so much because it was a new deed, so it doesn't matter. But the first points, I would draw particular attention to the fact that it made no capital contribution. This was a factor taken into account by the Upper Tribunal. As to filet, I mean, the Upper Tribunal then does set out its reasons in relation to RBS in greater detail at paragraph 61, but you have that there. Filed, again, Filed's situation is dealt with by the Upper Tribunal at paragraph 62, and these are the further factors that the Upper Tribunal says supports the FTT's decision, and the part of the reason that the absence of any evidence from Filed. Royal Bank of Scotland gave no evidence at the FTT. Filed gave no evidence at the FTT as to what they were doing or what they were intending to do, or what their role in the agreement was.
What relevant evidence would they have given?
But
Could they have given?
they may have given evidence as to whether they thought they were consenting to any consenting to the general partner doing anything on their behalf.
Well, they consented to whatever the terms said they consented to. Wouldn't have done them any good to come along and say, well, we didn't realise that we consented to this, if that's what the deed actually did, would it?
I accept that. I accept that. Well, we don't know why at all, what their reasons were for entering into this, or what they thought about it. That's all I can say.
But it's all got to be done on an objective basis, so what they subjectively thought they were doing, I wouldn't have thought matters very much.
Yes, in so far as that, I was trying to work out what relationship has been created. And if there is some doubt on the documents,
Yeah.
As to what relationship has been created, then because the document doesn't give the right name, then it may be.
Oh yes, sure. But I think somebody somewhere, one of the tribunals, quotes from that old 19th century case, when saying I don't mean to become a partner doesn't really help you very much if that's what those are the obligations you actually take on.
That's perfectly true. Yes, that's true. I think the Upper Tribunal's main point was that what the Upper Tribunal appreciated, that Filed's dealings were all in the Cayman Limited Partnership. The relationship, when there was a change in the relationship, there was an assignment by Royal Bank of Scotland of its interest in the Cayman Limited Partnership, the separate partnership, to Filed. And Filed is then treated as making a capital contribution to the Cayman Limited Partnership. But there was no attempt of the Royal Bank of Scotland to assign any interest it had as a partner in the UK limited partnership, and that's the inference that is being drawn is that there was no interest in the lower tier partnership. It was all the structure was that Royal Bank of Scotland and Filed would become partners in the Cayman Limited Partnership.
Yeah.
That basically takes me to what I was proposing to say on issue 1A.
Well, that would be a very convenient moment then. So we'll start again 10 o'clock tomorrow.